All right, so let's go ahead and go back on the record. We're on the record before the Medical Board of California in the matter of the second amended petition to revoke probation and accusation against Scott Ewing, MD. It's agency case number 800-2018-041694, OAH number 2020-010-010. My name is Warren Wong. I'm an administrative law judge with the Office of Administrative Hearings. To establish a quorum for the record, may I have the members identify themselves, starting with Ms. Lubiano.
Lori Rose Lubiano.
David Wormuth.
Ronald H. Lewis, MD.
Dr. Randy Hawkins.
Is Rick T.J. Watkins.
To let the record reflect that a quorum is established. And may I take the appearances of counsel, starting with the Deputy Attorney General, please.
Good morning, Your Honor. John Gatchett, appearing from the Attorney General's office on behalf of the complainant in this case.
Mark Von Esch on behalf of the respondent. Dr. Ewing, who is also present.
Good morning, counsel. All right, so this case, this is the date, time, and place set for oral argument in the notice of hearing for oral argument. The board has issued an order of non-adoption of proposed decision and has decided to determine this matter itself, and it has invited discussion on whether the proposed penalty should be modified. The following process and time limitations will apply. Petitioner has 15 minutes for opening argument. The Deputy Attorney General then has 15 minutes for a response, and then petitioner has 5 minutes for closing, and the Deputy Attorney General will have 5 minutes for closing. The time limits will be strictly enforced, and the argument should be based only on the existing record and shall not exceed the scope of the record of duly admitted evidence. No new evidence will be heard. The panel members may ask questions of the parties to clarify their arguments, but may not ask questions that would elicit new evidence. And then I or a panel member can ask a party to support a particular item with a specific reference to the record. At the end of oral arguments by counsel, Dr. Ewing will be given an opportunity to address the panel regarding penalty if he so chooses, in which case I will place him under oath. And then afterwards, the panel will go into closed session to discuss the matter. A decision will not be issued today, but at a later date. So just again, I remind counsel that arguments are to be limited to the existing record, and also that the board has received your written arguments and have read those. So with that, Mr. Gatchett, or excuse me, Mr. Von Esch.
Thank you. I appreciate the opportunity to be able to address you. I would say that both respondent and myself understand the duty of this board to protect the health and safety of the public. That's obviously a very important duty. At the same time, I think the ruling of the judge in this case articulated that there is another public policy of our state, and that is to work to rehabilitate those physicians and surgeons who have at times had their practice impaired or impacted by alcohol, drugs, or even mental illness. In fact, this policy is so strong that it's even been codified in Business and Professions Code 2350. I think if we look at the record in this case, the respondent was one of those physicians that back when he was initially accused and placed on probation, that fit within this category. The initial actions of the board indicated that he was suffering from alcohol, prescription medication, and had some mental or psychological conditions that contributed to that. His prior discipline then contained those allegations, and a number of conditions were put in place to try to protect the public, rehabilitate him, help him to become a better physician. Those included, of course, the standard PACE program, maintaining sobriety, attending group sessions, individual sessions, going to see his medical doctors and psychiatrists on a regular basis. Respondent has done all of those things. And I think one of the important findings from the standpoint of the respondent in the opinion is that the board did not establish at any time during the term of his probation that he was not sober. And so he has struggled for 3 years to do everything that is requested of him in regards to maintaining his sobriety, and he's done that. In that sense, I think that he's been somewhat of a model of how a physician who had problems when they were originally put on probation has improved. And if I look at a lot of the evidence in this case, most of it relates to stuff that went back to 2016, at a time when obviously the physician that's sitting next to me here today is a different person, is a different doctor than he was back in 2016. And I commend the medical board for implementing the appropriate measures to help that process. He continues to participate in continuing education, and even the things that he took in the PACE program, such as medical charting, record keeping, informed consent, all of these things have helped him to become better. And if we look at the accusations, a lot of the particular allegations relate to things that perhaps he wasn't as skilled in back in 2016. The bulk of the testimony at the hearing dealt with things, as I said, that happened years ago, back in 2016, before he was placed on probation. It's like looking in the rearview mirror instead of looking ahead or looking at the present situation. The post-probation complaints and evidence presented had to do with him having missed check-ins 15 times over around 1,000 days, 3-year period. And there was testimony both ends on that. Dr. Ewing testified that he had problems logging into the app. Gives a green light or a red light, and you can see that in the record. The evidence speaks for itself. But I think what's important when we look at that evidence is that for the last couple of years, he's been totally compliant, and he has figured that out, and there have not been any missed tests. And so again, the trajectory here is one that's extremely positive because he's done what needed to be done. And so I think that that problem's been resolved. There's no issues moving forward with that. The other issue had to do with a Dr. Lynn, who was also a doctor on probation, that had an agreement that they would help each other so that he was not in solo practice. At some point in time, Dr. Lynn stopped coming in. He didn't testify at the hearing, but we had a stipulation amongst counsel as to what he was to say. He never informed Dr. Ewing that he was not going to come to the one location on a regular basis, and that seemed to be an issue. But nothing ever alerted Dr. Ewing that was going to be an issue, and the evidence is, there's no evidence to indicate that any patient was ever seen or harmed as a result of that temporary lapse. I think what I'd really like to stress to you most of all, though, is that I think that the administrative law judge seemed to come to the conclusion that the purpose of discipline here is to protect the public and not necessarily to punish the respondent. I think that's a very insightful rationale on the part of the administrative judge. He came to the conclusion that there never was any lapse of sobriety on the part of the respondent, and that he also seemed to kind of view the evidence somewhat like I do, and that is that most of these things that were problems took place years before the hearing, and actually were all before his probation in 2016. He also, I think, looked at the fact that from 2018 on, there's never been any problem with this app on the telephone, that it seems to have been resolved to where Dr. Ewing knows how to do that. And so I think what I'm saying to you is that the fair, the just, and the right thing to do is to accept the overall conclusion of the administrative law judge, subject to whatever conditions that you feel as a board would be necessary to ensure compliance with concerns of the board, to ensure that he's practicing in a manner that's safe for the general public. And I guess what I'm saying to you is that whatever can be done, whether it's, as the administrative law judge determined, increase the length of probation, whether it's more frequent testing, whether it's more frequent monitoring, whatever can be done, it seems that the overriding rationale here should not be to punish, but to protect. And the fact of the matter is, since he's been placed on probation, there doesn't appear to have been any complaints that in any way, shape, or form Dr. Ewing is at this point in time not practicing in a manner that's safe for the public. He's a much better person. He's accepted responsibility for his admissions. And my hope is that we can use this as a model of success moving forward, that the respondent has done everything in his power and has complied essentially with all of the requirements of this board to be a good doctor. Thank you.
Thank you. Mr. Getchett.
Thank you, Your Honor, and thank you, ladies and gentlemen of the board. So let's talk a little bit about what we're doing here, which is the underlying facts are not at dispute. And so the findings that the board non-adopted we're not really discussing. We're discussing whether the penalty imposed by this ALJ was appropriate based on the findings that were done. And so looking at this case, and if you step back and look at what was proposed, was 2 years additional probation, and then kicking his substance abuse terms back to year 1 and increase the testing. The question that the board has to ask itself is, does that protect the public? By statute, the highest priority of this board is protection of the public. It's not rehabilitation of the respondent. And so we have to go back and look at the initial decision. What was this initial decision? It was a stipulation where the board gave him a chance based on multiple patients that he had poor care with, gross negligence, repeated negligent acts. He's a cosmetic doctor, and he kept on making mistakes. He was bad at record keeping. He also had a substance abuse problem. There was a disciplinary consideration of a 2004 DUI, a 2010 DUI, and then a drug conviction where there was a battery on a peace officer. All those things were wrapped up into that 7-year probationary term. And one could say that in 2016, when this board gave the respondent a chance to keep his license, that the board was giving him one chance to keep his license. Not 2, not 3, not 12, one chance. Now we look at the current case that's before the board. It is undisputed, Mr. Von Asch did not even bring it up, the 2016 case. Now, is that a probation violation case? No. In time, it occurred before he was put on probation. But it can be used in this way. If you had known about that case, which was another case involving patient care and failure to keep records, same as the conduct in the 2014 and earlier cases, would you have given him probation? And I think the answer is no. You would have revoked his license. At the very least, you would have placed him on a suspension of a significant period of time, maybe as many as 180 days. So that case does have relevance. It has relevance to show that the respondent was continuing his disciplinary behavior that was should have resulted in discipline long into 2016. Okay, well, what about his probation violations? 15 failed check-ins, 3 missed tests over a 1.5 year period. Counsel points out that, well, those issues have resolved themselves. Those issues resolved themselves because the board issued cease practice orders and a series of letters to him with cease practice orders. If he didn't come in compliance, he would have been under a cease practice order, revoked. That's why he came in compliance. I would note that even during that time, he was not truthful to the board. It was found in the underlying cause of action in this case that he sent a letter as part of a quarterly declaration where he signed to this board under penalty of perjury that his first missed check-in was in April, when in fact it was in May. So he was already in that period of time being dishonest to the board. And may I remind you, this board gave him 1 chance. The other issue is that from September 28, 2018 to May 23, 2019, he was in solo practice. The entire scheme of why he was placed on probation with a no solo practice term was to prevent no solo practice, to make sure that someone who has a substance abuse history and a history of many patients that have been harmed is monitored. And for a period of almost 8 months in the underlying case, it was found, this case, that he flaunted that. He worked without another physician in his practice. So, those are significant errors. Those are errors that typically lead to revocation, imposition of the original decision, taking away his license. And so when you look at the ALJ's final analysis, well, that we didn't prove that he was ever not sober. We don't have to prove he's not sober to violate his probation. Missed tests are like being intoxicated, because when you miss 3 tests, each of those tests, we have no idea if you were drinking or not, or using an illicit substance or not. And so those are how we should look through the lens of those missed tests. The ALJ did very little to examine whether continuing this respondent on probation was in the public protection, was public safety. Instead, it appeared the decision resolved around the idea of, well, we want to continue to rehabilitate the respondent. And that's not this board's goal. This board's mission, by statute, is public protection. Looking at Mr. Von Esch's briefing, I did want to point out a few things I noticed. First, looking at his statement that simply failing to be able to find one medical chart would not constitute gross negligence, nor shall it be sufficient to revoke the medical license of a physician, that's just incorrect. The case that the board has is Curl v. Medical Board, 1986, 189, Cal App 3rd, 1040, at 1052 to 1054. And I gave a copy of that case to Mr. Von Esch before we got on the record. In that case, it is clear that failing to document when it affects the treatment of a patient is gross negligence. And in fact, that's what the ALJ found correctly in this case. In our 2016 case, what was the failing to document? Documenting the risks and benefits of the side effects of the medication and the procedure that he was about ready to perform, giving the patient an opportunity to decide not to have a completely voluntarily cosmetic procedure so they would not have the side effects they suffered from. That is a big deal in cosmetic procedures because these are elective cases, and if patients are not given a full risk and benefit analysis of what they're actually undergoing, even if they have a known complication, they're not given that opportunity. They may end up with a complication that they would not have chosen if they had had a full and informed decision. Mr. Von Esch said that the evidence regarding unlicensed practice of medicine was such that it really should be discounted by this board because there was no evidence indicated that the respondent in 2016, when he's working at that day spa, was doing something illegal. I will point out that it is actually illegal. That's why the ALJ found those in the case. The 2016 case, the reason why the board has those is actually a number of reasons. One, if the owner of your day spa, and this was not a turnkey operation, this was an operation where the respondent was coming in, working as, quote, the medical director, but he was subservient to a non-licensee who owned the day spa, that medical spa director now is subservient, the licensee is subservient to a non-licensee in terms of patient care and decisions that are made. Furthermore, if an issue comes up that someone needs to file a lawsuit or seek discipline with the medical board as a patient, they can't go after the medical spa owner because he's not a licensee. So in that sense, public protection is not served when the respondent was working in a non-licensee area. In terms of intentional violations of probation, that's not the standard. It does not require that the respondent, while on probation, said that we have to prove evidence that he decided, well, I'm just not going to follow probation, I'm just not going to do that. No, it's his burden, his responsibility. He's the probationer. So it was his responsibility to make sure he could use the app correctly, not miss check-ins, and not miss call-ins. It was his responsibility to make sure that he was not violating the no solo practice term. And he didn't do that. And so based on the totality of the evidence in this case, and based on the record before the board, it's the complainant's position that revocation is the appropriate disciplinary penalty in this case for public protection. Revocation because if the board had known about the 2016 case, it may very well never have entered a stipulation in the first place with the respondent. And based on his time on probation, which has been, I think the record is very clear, a series of staff having to send him letters, threatening cease practice orders, issuing cease practice orders to get his compliance, that the initial probation at this point should have the original disciplinary order issued and the stay should be lifted. Thank you.
Thank you, Mr. Barnett.
Thank you. Let me just respond to some of the things that counsel stated. First of all, he handed me, before this hearing, this case of Curl versus Board. Factually, I think this is a totally, completely different case than one where, in the facts of our case, where one medical record could not be located. This was an anesthesiologist doing a surgery, assisting in a cesarean section as the anesthesiologist, who failed to note the vitals at every 5-minute intervals as he was required to do. I think it's a totally different situation because one, surgery is a tremendous risk to the public, and the testimony at the hearing was, despite this chart not being able to be located, and I'm sure everybody at one time or another has been unable to find a file or a chart, was simply that his custom and practice was always to perform informed consent. Yes, he didn't have the chart to prove that he did it, but the custom and practice throughout his entire career was to always verbally at least do that with a patient in regards to a Botox injection. Now the whole incident talked about with the day spa is very interesting. Yes, there are statutes that talk about you shouldn't aid or abet somebody who doesn't have a license in practicing medicine, but that's not what happened here. He was working at a day spa. He didn't share any income with the owner of the day spa. He didn't take any direction from the person at the day spa. They simply scheduled Botox and Dysport injections of a cosmetic nature. He would come to the office, he would perform them, he would keep the revenue from them. They had absolutely no control or anything to do with it. And it would be like me as a lawyer going to a senior center and having them say, okay, Mr. Vadish is going to be here on Fridays to do your will or your trust. If I don't share any money with them, if I'm not doing anything that would actively involve somebody practicing law, I would say that's totally legitimate. There was no evidence whatsoever that anybody other than Dr. Ewing had complete control at every procedure done there. And so that is really just a red herring. There was no evidence in this record to indicate in any way, shape, or form that he shared monies, acted under their control, or did something inappropriate, or assisted anybody else in doing any type of a medical procedure. Now, whether the board knew about this 2016 complaint or not at the time the probation was agreed to, I don't know how you would have ruled. I would assume that you would have probably found that simply not charting to indicate that you had done the implied consent would probably have been the least of the important aspects when we considered the other cases that we dealt with at that time. Now, I think there's a reason why we should typically defer at times to more than just a record and take a look at the recommendation of what an administrative law judge has decided and recommended. You know, in our system, an adversarial system, we put on evidence and we have witnesses. And it's very important sometimes to have the ability as a trier of fact to actually see the person, see their demeanor, to be able to evaluate their veracity and truthfulness. And I think it's an important aspect. And I think this judge, hearing all this evidence and the totality of things, tried to do the right thing in implementing a remedy that would fit the evidence. And although this board, of course, has the discretion to do what needs to be done to protect the public, Dr. Ewing and I are certainly willing to follow whatever lead the board would want to do in that regard, short of suspension or revocation. I think it's important that we look at this case not from an emotional standpoint, but again, consistent with protecting the public. We've seen no incidents in the last 3 years where the public has in any way, shape, or form been harmed. We can structure something that is fair, that is just, and more importantly, that I think would protect the public. And therefore, I think that this board should either reconsider adopting the judge's decision or coming up with a remedy consistent with allowing Dr. Ewing to continue on the road of improvement of being a better doctor. Thank you.
Thank you. Mr. Gatchett.
Thank you, and I'll just be brief. I don't know if the state bar would agree with the idea that an attorney could go to a senior center and set up shop based on the senior center saying, hey, we're having legal days and this is the attorney we picked. Much like the day spa, the fact that the doctor is going to the day spa and the day spa is giving space for him to, quote, do his practice, the ordinary patient does not know the day spa in that situation is actually not owned by the doctor. That's why it's aiding and abetting the practice of medicine. That's why it's illegal, and that's why the ALJ found as such. Taking the recommendation of the ALJ, so legally, this board has not adopted his decision. That recommendation at this point has no legal effect on this board. And there's two things that we have to look at that we have to separate. One, yes, should the ALJ's determination of credibility be given great weight? Of course, that's actually how we do a review. And so his credibility determinations that he made of the witnesses, yes, we should follow those. And in fact, what he found was that everything in the accusation was found true. Should we follow the recommendation that he came up with? And the answer is no, because this board has not adopted this decision. This board is deciding whether, based on the record before it, the penalty imposed is the correct penalty, and whether or not this board wants to have its own penalty. And that's what this board is doing. And so based on the arguments here, and based on the underlying record, I think I made it very clear. From complainant's position, the proper penalty in this case is revocation. Thank you.
Thank you. Dr. Ewing, do you wish to address the board regarding penalty?
Yes.
Okay, so please raise your right hand, please. Do you solemnly swear or affirm that the testimony you will provide in this matter will be the truth, the whole truth, and nothing but the truth? You may put your hand down whenever you're ready.
Thank you for your time.
I want to tell the board that I feel my issues were mostly due to substance abuse, if not completely. I accept full responsibility for them. I have been sober since September of 2016, and it's been a big change in my life, and it's been a very positive change in my life. I realize that is not the concern. I understand that public safety is the concern, and I want to tell the board that since I've been sober, I feel very confident that I can safely treat the public, and I ask for the ability to continue to prove that. Thank you.
Any questions by the board?
Ms. Lubiano?
No questions.
Mr. Miller?
No questions.
I usually am the last one to go, so, in the chair, so, maybe no? No? I have,
I've got two questions.
Mike, please.
Mike.
Oh, Mike.
and then I'll go after you.
So, Mr. Ewing, this question is for you. When you missed the 15 callings and the 3 missed tests, did that ever occur to you on just a conscious level when you got the citation? I think you got 2 citations. You argue that one of them you never received, right? But you've had extensive conversations with board staff about this app, and them continually telling you can call in as well. Why was that never an option for you?
Well, the app is more convenient. However, calling in was always an option. The issue was a technological problem I had with the app. I don't know if you understood what my complaint was with it, but I would check in about at midnight the night before and plan my day for the next day. And sometimes unfortunately, I feel like I might have been tired at the time. Before the time I decided to start checking more than once a day. And I would check that, I would look at the screen, it would show me a green screen. And I wouldn't find out that I had any missed violations till a month down the road when I got a letter. And there would be multiple violations because I was looking at the screen for the day before, showing me that I had, a green go, which is not to test. And so I would assume that I checked in when in reality it was just showing the login from the day before. So I did understand that I could make a phone call. It took me too long to recognize how serious the board was about these check-ins. I regret not putting more diligence towards calling, checking multiple times a day, having safeguards in place. I regret that I did not do that. I have figured it out. However, I understand that it's taken me longer than it should have.
So the second question is, when you did your evaluations, I can read it, but just to shorten this whole thing, is at that point, the people, the experts that you consulted with that did the evaluation, they essentially said that the only reason why you can practice safely is if you are under these safeguards. The substance use disorder is being addressed, and this case is at the heart of this. And so to hear you say, and here's the question, that you didn't take it seriously, I want to understand, how do you feel about that today? Do you take it seriously today?
I do. I've always thought it was serious, but I have an issue with attention and attention deficit disorder and it makes a daily check-in difficult for me. But I've never taken the whole situation lightly. I just had to address what I had to do as far as safeguards and checks to make sure I logged in. But as far as taking the whole situation seriously, while I haven't liked it, I definitely have taken it seriously, and I do take it seriously today.
How did you manage the first part, the first 6 months off to have no issues, and then the issues started arising after that first 6 months? Because the first 6 months you had no problem, web-based, everything, and then it shifted to the app. So you, in the record, you said it was convenience. I just want to hear from you, what was that decision? And when it stopped working, why didn't you choose, well, let's go back to web then? Does that work?
I don't remember exactly when I started using the web versus, I've always kind of used all of them. I think it's just coincidence about the first 6 months, because it's not that I had it's just over time, I think it's human nature to have a difficult time to continually log in and to remember to do that every day. I've thought a lot about this, why I have been unable to log in. And it's definitely not that I haven't been sober, and it's definitely not that I don't want to. I feel that it's partly due to my attention problem and partly due to me feeling mildly frustrated about the decision and the penalties that have been placed on me. And I've had to come to full grips with the fact that my feelings about things don't matter. What matters is the safety of the public and my ability to show sobriety, and also my ability to check in, not only for showing sobriety, but just to show that I can follow procedure. And I feel that in the last 2 years that I have shown a significant improvement in that.
And the final question is just this. Final question is, while you were in solo practice, did it ever occur to you that you were contravening one of the board conditions?
No, I never was aware that I was in solo practice. I had an agreement with a physician that he was coming to my office, and he started to not come as frequently as he was supposed to come, and when I continued to ask him to come more often, I can't control the actions of this other person. And he was still involved in patient care. We were both involved in each other's patient care. So I never felt like I was in solo practice. When as soon as I found out that his intentions of not coming there was news to me, when he told the medical examiner.
Thank you.
Doctor, two quick ones. Is your ADHD under treatment now?
Yes.
Right. And do you realize now that you're now at a higher level of frequency of testing because of the missed test before?
Do I realize what?
That if you were to be allowed to not have your probation revoked, you would be starting at a frequency of testing at the highest level, which is where you were when you first started testing. Do you realize that it's a higher frequency of testing that would occur?
Yeah, I'm aware. I'm not so concerned about it anymore. I feel like I have that issue handled, and I am aware that it would go that way.
Dr. Ewing, good morning. I want to ask you about your board certification, and are you board certified in any medical specialty?
No.
No. Okay. I see in the record that you called yourself a cosmetic surgeon. Is that true?
I called my practice cosmetic surgery. I don't know if I call myself a cosmetic surgeon, but I definitely implied that I did cosmetic surgery.
Okay. But is any of your training in the field of cosmetic surgery, such as you've done with several of the patients mentioned?
I've had numerous training, but not a formal fellowship or board certification in cosmetics. But I have done extensive training on my own.
Okay, so again, at no time, or correct me if I'm wrong, did you advertise yourself as a cosmetic surgeon?
I did advertise myself as a cosmetic surgeon.
Okay. Now, next question is regarding your sobriety. And I think that's, you stated since 2016, is that correct?
Yes.
Okay. And what milestones have you reached so far to maintain that sobriety? What are your activities that allow you to maintain your sobriety?
Primarily, it would be the program of Alcoholics Anonymous, maintaining a sponsor and attending meetings and working the 12 steps. I realized I had a nudge from the judge, so to speak, and that I have these, these logins, but I realized that it's not just about physical sobriety, it's about emotional sobriety as well. And I think that through working the steps, that's where I would start using a word like milestones, because that's where you start to see, lasting behavior changes that are not just about being sober, but that are about your mental state and the way you look at yourself when you look at situations.
Thank you.
Okay, are there any further questions from the panel? Hearing none, this concludes arguments in this matter. The record's closed, the case is submitted, and we are off the record. Council, I'll just remind you that the court reporter will have a form for you shortly. I think we are going to take a short break, and then after that, move